never in our wildest dreams, never in our wildest dreams, never in our wildest dreams.
If Robert had ever expressed his wishes on paper, Robert Wendland was 42 years old when he was in a car accident here in Lodi, and he did not negotiate the on-ramp to the freeway, and the pickup truck he was driving flipped off. That was in September of 1993. And he suffered what's known as an anoxic brain injury, which means that he was deprived of oxygen for a period of minutes. So he was taken from the accident scene to the hospital in an unconscious state. And he actually stayed in a coma for 16 months.
When he started receiving therapy after he woke up from the coma, we were hopeful that he would be able to recognize us and have some sort of meaningful interaction with us. And we figured over time it would improve. And it never happened. I never felt any sort of connection with him in terms of him understanding me and recognizing me as his daughter. And the same with the rest of us. I didn't notice him reacting any differently with us than he would with anyone else who walked in the room.
He could only minimally respond to people. He never recognized Rose or the kids as far as they could tell. He couldn't take care of himself at all, but he could clearly voluntarily move. He would follow certain simple commands, but that's about the extent of his ability.
When they were doing therapy on him, I felt like they were kind of training him like a monkey. And I don't mean that badly. It's just that they would teach him something, and it would take hours for him to, say, grab a block. And the next day, they would have to do all the stretching, hours again, just to be able to grab that same block. And it was very, very disturbing. And after time, it was enough was enough. There was no point in it.
Because of his neurological damage, he couldn't swallow. So a gastrostomy tube was put in to feed him. And after he woke up a bit, he began pulling that tube out. And after he pulled it out the fourth time, Rose and the kids thought that it was pointless to continue putting it back in. The doctors had told them that Robert would never get any better. He would never become more conscious or able to take care of himself in any kind of even minimal way. And they were convinced that he wouldn't want to live that way. So Rose decided not to reinsert the feeding tube. Word became public. Robert's mother heard about it, found a lawyer, and got a temporary restraining order forbidding Rose from stopping the tube feeding. This was in the summer of 1995, and that's when the litigation started.
Well, based on her testimony at trial and what the California Supreme Court concluded was that it was a subjective assessment on Rose's part that Robert's quality of life was not acceptable. She really didn't present any evidence that there was any medical justification for pulling the feeding tube and bringing about his death. It was a values judgment, pure and simple. She contended that it wouldn't have been acceptable to Robert. My clients, of course, had a totally different viewpoint.
Robert didn't have a living will, but Rose said they discussed his wishes 3 months before his accident, when her own father's life support was turned off. Rose says Robert made it clear he would not want to be kept alive on a feeding tube.
He had stated that at this point, if anything ever happened to him, if he could not be, like he always said, a father, a husband, or a provider, then what's the purpose in life? We have discussed that many, many times, and his thing is if he was ever in a diaper or he was ever had a trach or wasn't able to do anything on his own, then let him go.
And so the issue in this case became very simple. Who gets to speak for Robert? Okay, and if the person is speaking for Robert, then how do we satisfy ourselves that that person is really saying what Robert would want to have said?
The legal battle actually lasted about 5 years, 5-6 years. It was very difficult for us. Robbie was in elementary school, Carrie was in junior high, and Katie was in high school. And it actually took a lot of my energy and my time. They had to grow up very fast because of all this.
It became a full-fledged, all-out war with a lot of emotion for the attorneys too. And it was a long, stressful battle, and I lived in fear that I would lose this case, and I would have to sit Florence Wendland down someday and say, I lost. And now you have to go sit at your son's bedside as he dehydrates and starves to death. It's been very hard watching her struggle with this.
The Supreme Court decided we could not remove Robert's feeding tube. And needless to say, this was after he passed away. the sad thing is it affects all of us, the whole society. It affects my future, your future, my children's future. For the fact is that we have no right to decide on our own loved ones.
It could have all been avoided had Robert executed a durable power of attorney for health care. If he had signed that and given Rose his authority to make medical decisions on his behalf, that would have been the end of this issue. Rose would have decided to stop the tube feeding, and there would have been no ability of the mother to challenge it legally.
In general, there are two kinds of advance directives. One is often called a living will, and that's a general statement of your preferences, your philosophy, your thoughts about how you would want to be treated under a specific set of circumstances. Unfortunately, it turns out that it's very difficult to implement that in any kind of legal situation, because rarely do you anticipate exactly what's going to happen to you medically. So the other form of advance directive that we have is something often called a durable power of attorney for health care. To simplify it, it's appointing someone to make decisions for you, someone who understands your philosophy, who can decide for you in a way that would match your wishes based on a human understanding of who you were and how you would react to that situation. That is therefore our preferred form. We like to have a real, live human being who can look at the current facts and the current situation and make a judgment as to what you would want to have done.
About 2 million people have traumatic brain injuries a year in the United States. About 350,000 of those people are hospitalized for the brain injury. About 2,000 of those people wind up with permanent coma or persistent vegetative state. And there are in the nursing homes in the United States at the moment 30,000 people with that vegetative state, not being able to recognize anyone, speak, or take care of their own needs.
In my experience, people as young as Mr. Wendland, people in their 40s, virtually never have an advance directive. In fact, the people who most frequently ask me about advance directives, the elderly, even among that group, there are very few that have an advance directive.
The very best evidence is that at most, probably around 10% of the population has one of these directives in one form or another. Why don't people do it? Who wants to talk about death? Who wants to talk about dying? Who wants to deal with the possible terrible things that could happen to us, either from disease or injury? Second, you got to think about what you might want or not want. And the person might say, well, gee, if you're going to make me this person who can make these decisions for you, we got to talk to each other. Well, a lot of people don't know how to talk about that. I mean, for example, when my wife's grandmother was getting quite elderly and not feeling well, she'd heard about these powers of attorney. She wanted one because she knew that there were things she wanted and didn't want if she got very sick or was dying. But when I sat down with her to do it, Grandma had no idea what to tell me. I had to ask her questions and get some feeling from her what it was that she was really concerned about.